I'd like to discuss with you a matter that's threatening the effective prosecution and defense of felony crimes that take place in the city of Clinton. I'm going to take a little bit different tack than normal. I'm going to tell you in advance what I'm going to say and then say it and then remind you in the end what the point of all this is. The city of Clinton desires a legal resolution to the matter I'm about to talk to you about. 3 takeaways for you to consider as I go through this talk. First, the municipal judge is acting within his statutory authority as the charges originate in the city of Clinton with Clinton Police Department as the arresting officers. Second, the municipal judge tries to appoint the Hinds County Public Defender, which from time to time I may refer to as the HCPD, and is offered to make sure the office is advised of the schedule. Third, when no one from Hinds County Public Defender's office is present, the municipal judge appoints our public defender. It is imperative that the city and all defendants needing counsel are afforded that constitutional right, and that's a 6th Amendment constitutional right, and that is a right of representation. I believe that prosecuting and convicting criminals in Hinds County requires a cooperation between multiple agencies, beginning with the investigation of the crime through the dispensation of verdict and beyond. This partnership between the police, the courts, the prosecutors, and defense attorneys is vital to the appropriate dispensation of justice for the accused and the victims alike. When one of the legs of this partnership fails to participate appropriately within the constitutional framework, the consequences can be tragic for all parties involved. At issue today, the city of Clinton has had problems in the defense of felony cases originating within the lawful jurisdiction of this municipality. I am concerned that unless this issue is addressed and brought to light, the effective prosecution of criminals and the public safety of residents could be placed at risk. Of issue is an extremely serious point relative to the constitutional prosecution and defense of defendants in a criminal proceeding. The Hinds County Public Defender's Office refusal to represent indigent felony defendants as assigned by the City of Clinton judge in clear conflict with Mississippi Code 2123-7, powers and duties of a municipal judge. This code states that the municipal judge may conduct preliminary hearings in all violations of the criminal law of this state occurring within the municipality. At issue is the refusal of the Hinds County Public Defender's Office to handle preliminary matters in Clinton. This refusal to participate in Clinton's municipal courts began several years prior. Previously, the Hinds County Public Defender refused to attend the City of Clinton's court. So, the city prosecutor would go to the Hinds County courthouse. Despite attending court in Hinds County, cases would languish due to absentee judges or other unexplainable circumstances. State law requires that all defendants receive an initial appearance within 48 hours of charges and must receive a preliminary hearing within 14 days if requested. Defendants must receive an indictment within 90 days. Due to the inability of the cases to progress through the Hinds County court system, the City of Clinton now conducts preliminary hearings in Clinton Municipal Court in accordance to applicable state statute. Clinton Municipal Judge Steve Boone appoints the City Public Defender for the preliminary hearings and then binds them over to the grand jury. Once a case is sent to the grand jury, the case is handed over to the Hinds County Public Defender's Office in accordance with state law. According to Judge Steve Boone, the City of Clinton has the authority, the statutory authority, to conduct all preliminary hearings for misdemeanors and felonies occurring within our lawful jurisdiction. Hinds County Public Defender's Office representatives have now created a constitutional quandary by refusing to represent these defendants. As a result, many defendants languish in jail without representation. In refusing to represent indigent defendants, the HCPD is asserting that the City of Clinton does not have legal authority to hear preliminary hearings in city court. Once again, referencing Mississippi Code 21-23-7. The Hinds County Public Defender's Office representatives are mistakenly referencing state statute, state Supreme Court rulings, and Mississippi Rule of Criminal Procedures, or MRCP, in relation to the appointment of the Mississippi Public Defender to represent felony cases in Clinton Municipal Court. In their first objection in accepting Clinton cases, the HCPD representatives references an order from the Mississippi Supreme Court relative to Mississippi Code 25-32-9. This case and subsequent order is in regards to a circuit judge attempting to remove HCPD from cases, wherein Clinton court officials are attempting to get HCPD to represent our indigent defendants. The second objection erroneously cited by the HCPD is Mississippi Code 25-32-1, where they claim that only the Board of Supervisors have the authority to establish a public defender's office. Nothing in the statute precludes a municipality from appointing a public defender. City officials are willing to allow HCPD counsel to represent cases in Clinton. It was only after HCPD's refusal to represent indigent defendants in Clinton and cases being delayed in Hinds County Court that Clinton Municipal Court Judge Stephen Boone began the current procedure. Let me repeat that again. It was only after HCPD's refusal to represent indigent defendants in Clinton and cases being delayed in the Hinds County Court that Clinton Municipal Judge Steve Boone began the current procedure. Third, the HCPD erroneously cited Mississippi Rule of Criminal Procedure 7. City officials are appointing the city public defender to represent indigent defendants as a last resort when no representative of HCPD is in attendance. In reference to MRCP, that's the Mississippi Rule of Criminal Procedure 6, which outlines procedures for preliminary hearings, city officials are in clear constitutional compliance by ensuring that defendants receive a preliminary hearing within 14 days if requested. Efforts to appoint legal counsel for indigent individuals in felony cases arising within Clinton's lawful jurisdiction have been met with continued roadblocks from the Hinds County Public Defender's Office. These continued obstructions threaten the constitutional rights of defendants and subject the entire criminal justice process to an unnecessary diversion. Once a case is bound over to the grand jury, we, the City of Clinton, have no jurisdiction on the case. It is a responsibility of the District Attorney's Office to present the case for indictment and the Hinds County Public Defender's Office to represent indigent defendants once they receive the case from the District Attorney. The City of Clinton desires a legal solution to this matter. 3 takeaways must be addressed to protect the criminal rights of defendants and victims. They are: 1, the municipal judge is acting with his statutory authority as the charges originate in the City of Clinton with Clinton Police Department as the arresting officers. 2, the municipal judge tries to appoint the Hinds County Public Defender and has offered to make sure the office is advised of the schedule. 3, when no one from Hinds County Public Defender's Office is present, it is imperative to the city that all defendants needing counsel are afforded the constitutional right guaranteed to them in the 6th Amendment. It is the expectation of every resident of Clinton to be safe and secure in their own community, and it is unconscionable of the Hinds County Public Defender's Office to allow criminal cases to go undefended in violation of constitutional rights. So I'll open the floor now for any questions that you may have.
Can you tell us a little bit more about the cases that are being impacted? For example, maybe how many inmates are staying in jail because there is no public defender, and what kinds of cases these are?
Well, once we do the case here in this court and we pass it up to Hinds County, we lose all jurisdiction in it. That's a question then for the Hinds County Public Defender and the DA's office. We don't keep track of that. But we do insist that we do our initial cases here so that process can be, those days and that timing of the process can begin. I'm not interested in anybody being in jail any longer than they have to be, but I'm also not interested in them being in jail for extended periods of time and being set free because they could never get a case tried. But even more important than that, the refusal of the public defender to try our cases because we are doing it here instead of them doing it here is absolutely wrong. Absolutely wrong.
Any feedback from Hinds County, or have they said anything to you about this?
We've had a series of letters that has gone back and forth, and it's finally just reached the point where we came to today. So I think we supplied you with that background information.
Yeah.
I met with her yesterday and she claimed she didn't have the staffing to actually have people come over here and work in the municipal courts. It was easier for her to work to handle the cases over in county court.
Well, that's fine. Why not accept our help? If we're constitutionally allowed to do, or legally allowed to do it, why not accept the help that we're offering? These are capable and competent attorneys. We don't let people in our court, or the city doesn't appoint people in our courts that aren't qualified. So we can be an assistance to them, an extension of their office versus what appears in their eyes to be an adversarial role.
How big of a problem is this and how long has this been going on?
It's been going on for years, off and on. It's just kind of become an issue here since the appointment of a city's full-time judge, and we're able to generate on a daily basis and send people forward to Hinds County for their trial process versus waiting and doing it just one day a week.
How much of a does this push you back? How much does it slow you down, backlog?
Okay, we'll have to get you those numbers. But that's what we're trying to prevent, is any kind of backlog. But we'll get you those numbers when we're through here.
And how is this affecting, I guess, the residents of Clinton?
Look, we're a very anti-crime city. And I mean, it may sound like a silly statement to make, but the fact of the matter is we want to find the criminal, prosecute them as quickly as possible, giving them a fair opportunity to be represented. Fairness has to come in once they come into the court system to assure that they're properly represented by a public defender and that they're properly, and at the other side of the case, by the prosecutor. If we are sending people to Hinds County to the public defender's office and they are delaying or they are not getting to these cases because of their own admitted staffing issues, then that is not working well for anybody. The system is breaking down. My goal is to get these accused to the proper place in the required amount of time in the hopes that Hinds County can carry it forward and then get them on trials on a regular basis or on within the time frames that are allowed by the Constitution and by their rights. I'm not interested in playing games here. I'm not interested in pointing fingers. When the public defender says they're not going to accept our indigent cases, that to me has serious consequences that I'm not going to stand for. I'm sorry about their staffing issues, but once again, we're willing to help them by doing it here. And we have qualified, capable people to do that, following the same procedures and proceedings that they would. Why is this an issue?
Are they not accepting your help as you offer it?
What they said is, we will come to your proceedings if we have somebody. Otherwise, we're not going to allow that indigent to be represented, or we're not going to take the case in Hinds County.
And there was no solution offered?
We're here. We're at this point right now. And I think it's important for the people in the city and Jackson and in Hinds County to know, because this isn't the only place it's happening. I mean, it's happening in other cities in our county. We don't need in this county to have criminal activities in any way interfered with or backlogged over, I don't know, a misrepresentation or a misreading of the statutes or any other thing that gives that element any kind of advantage. We need to move forward with this. We need to move forward together, and we need to move forward quickly to expedite these charges and not let it just languish on and go on and go on. Spats like this are completely unnecessary.
Does this cause keeping your jails full if they're not prosecuted or not adjudicated?
Like I say, when our police force goes out, and they work very hard to bring these guys in, we have a full-time judge now, and they are seen very quickly and then moved to Hinds County. So the issue isn't, I don't think, with our jails. That's not the issue. The issue is getting the process started on the accused so that they can then go and take the process that the DA goes through and the public defenders go through for the trial can begin as soon as possible.
She said yesterday that under the law, that once they sign that affidavit of indigency, I think it's called, that only her office can represent that defendant.
Incorrect. She is misstating and misrepresenting it. I believe I stated in here, let me look real quick. Mississippi Code 21-23-7. Here's the sentence: the Hinds County Public Defender's Office refusal to represent indigent felony defendants as assigned by the City of Clinton judge is in clear conflict with Mississippi Code 21-23-7. The municipal court judge may conduct preliminary hearings in all violations of the criminal law of this state occurring within the municipality. I don't know how she's misinterpreting that, but it seems pretty clear to me.
How many city public defenders do you have available that?
One.
Just one?
Any other questions? Thank y'all for coming.
Thank you all, I appreciate it.
Yeah.
You gotta watch out for Kenny, yeah,
Kenny,
You said you have some background.
you got a Kenny report?
Yeah.
You got a Kenny Stokes report?
Oh, no,
Oh, man.
All of the stuff.
Why'd you get our hopes up?
I haven't seen it. Kenny's been kind of quiet lately. What's up? You sick?
I don't know,
You've been reading the website then.
Yeah. I mean, I'm just talking about his usual stuff that he's doing.
Well, I'm loving his